6 immigration updates every U.S. visa holder must know by August 31st. The rules are shifting again, quietly, but powerfully. 6 major immigration changes between mid-June and mid-August could derail your application, threaten your status, or block your family's future in America. These aren't minor adjustments or distant proposals. They're real, active policies, rolling out now. If you're waiting, applying, or living in the U.S. on any visa, these changes matter more than you think. Every one of these 6 updates carries consequences. Some will hit you in the wallet, others will hit your timeline. One could even hit your family's eligibility without warning. Today, we break down each change in plain language, so you understand exactly what happened, when it happened, and how it could directly impact you. 1. The filing fee hike that can stop your case cold. Starting July 22, USCIS officially raised filing fees for multiple applications. This wasn't a subtle increase, it was a firm reset, driven by provisions inside H.R. 1. For months, applicants hoped for a grace period, or at least slow enforcement. Instead, the agency went straight to full compliance. Postmarked after July 22, you're paying the new rate, period. Here's where it gets more dangerous. USCIS announced that from August 21 forward, any application arriving with the old fee will be flat out rejected. No courtesy notice, no chance to fix it. Imagine waiting months to prepare your package, only to see it bounced back for a missing $20, $50, or $200 fee increase. That's now reality. This means even if your forms are perfect, even if your evidence is airtight, the wrong check amount will end your case before it starts. If you haven't yet filed, confirm your exact category's updated fee directly on the USCIS site, and double-check your payment before you mail or submit anything. 2. Family-based green card denials without warning. The second change is a quiet but powerful policy shift for family-based green card petitions. As of August 1st, USCIS officers can deny petitions without issuing any request for evidence or notice of intent. In the past, if something was missing, maybe a birth certificate, a joint lease, or a tax transcript, you'd often get a request for evidence. You could fix the problem. Not anymore. This new discretion means if your file isn't complete or your evidence doesn't convince the officer immediately, the case can be closed on the spot. The ripple effect is massive. A denied petition not only forces you to start over, it can trigger other consequences, like sending your case into removal proceedings if your status expires in the meantime. This isn't theoretical. Lawyers are already reporting clients whose petitions were denied outright for documentation gaps that, a year ago, would have been easy to fix. If you have a family-based case pending, or plan to file one, treat it as a one-shot submission. Triple-check your evidence, and front-load your package with every document they might ask for later. 3. The CSPA shift that could age out your child. For years, the Child Status Protection Act has been a lifeline for families with kids approaching 21. It allowed many children to lock in their age while the green card backlog dragged on. Until now, age was calculated using the FASTER dates for filing chart. That helped keep many H-1B children eligible as derivatives, even when the process moved slowly. On August 15, USCIS changed that. They'll now use the slower final action date chart to calculate CSPA age. For thousands of kids, that clock just sped up dramatically. Families from India will be hit hardest. Long EB-2 and EB-3 backlogs mean the final action date can lag years behind the filing date, making it impossible for some children to stay eligible. Once a child ages out, they lose derivative eligibility and must find their own independent path to a green card, often starting from scratch. There's a limited transitional cushion until the end of 2025, but it's temporary. If your child is nearing 21, review your case today with an immigration attorney who understands CSPA nuances. 4. Sports visas and the new gender rule. On August 4, the government added a controversial new factor to certain visa decisions: participation in women's sports by transgender women. This change applies to O-1A visas for extraordinary ability, EB-1 and EB-2 categories, and even national interest waivers when the applicant's career involves competitive athletics. Officials say the shift is about fairness and safety in women's sports, but critics argue it targets transgender athletes unfairly and injects politics into the visa system. In practice, this means a transgender woman seeking a sports-related visa could see her application weighed negatively, even if she meets every other requirement. This is not a blanket ban, but it's a discretionary factor officers can use. That makes it harder to predict case outcomes, especially for athletes, coaches, or trainers working in women's sports. Anyone in these categories should now plan for extra documentation, legal support, and potentially longer processing times. The political debate will continue, but for now, the policy stands. 5. H-1B layoffs and the grace period gap. The 60-day grace period after losing your H-1B job has always been a safety net. It gave you time to find a new employer or change your status without falling out of legal stay. But in recent weeks, reports show some H-1B holders are getting notices to appear in immigration court during that grace period, effectively treating them as if they overstayed. This creates a dangerous contradiction. On paper, the grace period still exists. In practice, some applicants are being pushed into removal proceedings before that time expires. Once an NTA is issued, your record changes. It can affect future visa applications, green card eligibility, and even travel back to the US after leaving. For laid-off H-1B holders, this means you can't rely solely on the calendar anymore. You need to take action immediately: job search, status change, or departure planning, within days, not weeks. Immigration lawyers are urging anyone in this position to document every step, keep copies of all communications, and seek legal advice as soon as the layoff happens. 6. The Visa Bulletin filing date alignment. Every month, the Visa Bulletin sets two key dates: the final action date and the dates for filing. Knowing which chart USCIS is using can make or break your ability to submit an adjustment of status. In July and August, subtle but important alignment changes between USCIS and the Department of State altered the filing timeline for certain categories. In some cases, applicants who expected to file based on the dates for filing chart found that USCIS required the stricter final action date instead. That delay can push your filing months, or even years, further out. It's a technical change, but it matters for planning. Filing early can lock in benefits like work permits and travel authorization while you wait for final approval. Filing late means waiting longer for everything. The takeaway is simple: never assume USCIS will follow the same chart as last month. Always check the latest bulletin and USCIS monthly adjustment filing page before making any move. Conclusion: 6 changes. 6 different ways your case can shift, stall, or sink, and they all happened in just the last 8 weeks. From fee hikes to sudden denials, from aging out kids to unpredictable grace periods, this is the new reality, and it's moving faster than most people realize. If you take nothing else from this, take this: every filing now needs to be perfect on the first try. Every timeline needs to be double-checked. Every risk needs to be addressed before it becomes a problem. The US immigration system has always been complex, but right now, it's also unforgiving. Staying informed isn't optional, it's your best defense. If you liked this video, don't forget to hit like, subscribe, and turn on the bell icon for future updates. Thanks for watching, see you in the next video.